Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Well, she found out.
What more can you see?
All right, welcome back. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for joining us this afternoon. Hopefully your lunch was as wonderful as mine, and I'm going to tell you about mine. Not that you want to know, but I want to tell you. My lunch, first of all, started yesterday. Really, it did. There's a long story here. It started yesterday with Mrs. R.A. making a delicious chili in the crock pot, slow cooker. Oh, so much flavor, so good. And I ate all that I could yesterday. And then I had some for second dinner, which is like the 11 o'clock at night dinner. And then I put the leftovers, what was left over from that, in the fridge. And I had it for lunch. It was that good. But not just this delicious chili, which Mrs. R.A. thought was too spicy. Yeah, she seasoned it, but she thought it was too spicy. But this morning, it takes like 3 hours, she made homemade bread. And it had just barely come out of the oven. I mean, like, too hot to touch. The loaves were too hot, and she dumped them out of the pans and set on the cooling. Yeah, they were too hot to touch. I've got the chili heated up in the microwave. I'm like, I need fresh bread with this chili. And everyone in my family, Mrs. R.A. included, told me, no, you can't. If you try to cut the bread now, it will collapse the loaf. It'll all be smashed. But I know I've got mad bread cutting skills, and I could do this. I could cut a piece off the end of the loaf without smashing this fresh loaf of bread, which is absolutely gorgeous. It is beautiful, beautiful bread. And so I'm arguing my case, and everybody, the whole family's like, Dad, don't do it. No, you'll ruin the loaf. And I'm like, whatever. So I'm getting out the cutting board and the knife and everything. And I set the bread on the cutting board, and I go out to the table, like sitting right in front of Mrs. R.A., just to prove that I can do this, right? And she makes a deal with me. She says, if you can explain this math problem to one of our children, then you can ruin that loaf of bread by cutting a piece off. I explained the math problem. It worked. And then I perfectly cut a piece of bread off this. And Mrs. R.A. obviously wanted to try some as well, and she did. And all the kids are like, can I have a piece? And I cut the loaf is gone. The loaf is gone. It got devoured. I cut all the slices off and dipped it in the chili. Oh, my goodness, it was so good. So if I have a nap this afternoon, if I get a little sleepy, it's because I had some just beautiful. When I say homemade bread, she ground the wheat this morning. We've got a wheat grinder. She puts in cups of wheat, grinds it up. It's literally, the yeast in the bowl, in the mixer, lets it rise the dough. It was so good. It was so good. Talks about fresh bread and chili. I'm sorry. I married up, but I married someone who can cook. No pictures. I cannot show you a picture of the chili because it is gone, and I cleaned up the bowl because that's what I do. I clean up after myself. I can run and get a picture of the bread because there are 2 loaves left of the 3 that she made. Anyway, the fresh milled bread, when the flour is hot out of the mill, it's just been ground, just been milled. Oh yeah, it's just good stuff. I'll see if I can get the recipe for you. She does have recipes for both of them, but recipes are like guidelines for her. So she's like, a little of this, a little of that, a little more of this. And she, especially with bread, it changes the amounts of what, water and flour you put in based on the humidity of the day. She knows exactly what, yeah. Anyway, I just thought I'd share that with you, brag about my wife and about my lunch. All right, where are we going to go? We have a couple things to, let's see. Do we have anything to talk about as far as what's happening in the world of true crime? I have to say, I saw a funny tweet, not true crime related, but weather related. As you know, our favorite weatherman, Mr. Weatherwatch, who's my podcast partner, we have a podcast tonight. It's going to be great. Please be there, 8 p.m. this channel. It's live, so join us just like this. Anyway, he has really opened the world of weather chasing to me, as he's introduced me to a bunch of different people, and I follow. Now I've got like weather chasers all over the map on my timeline on my Twitter feed. And one of those, and there I follow like the good, the bad, the ugly. I've got them all on there, so I can see the drama that goes back and forth. And apparently, there's a lot of drama there. And I won't say which side, if I'm for or against, but one particular weatherman by the name of Reed, who has the Dominator, posted today a couple hours ago, just a short little tweet. It just said, "I can no longer rent vehicles. This is understandable and fine." And that, for me, I just busted up laughing because these weather chasers, oftentimes they'll rent a car, pay for the extra insurance, and drive it through a tornado, and it totals the car. And for $20 a day, that's a cheap car. But he's now been blacklisted by all the companies, and so now he's like, well, that's out. Anyway, I thought that was funny. All right, where are we? Where are we in court? We've got a couple things going on. Judge Fleischer is back. Judge Boyd is in action as well. I thought we had, I don't know who this is. Who was that? I can't tell. Let's see. Oh, that's Chisholm. Chisholm. So we're not going to go there yet. Let's see. Judge Fleischer, he doesn't have anybody in front of him. Let's see if we can do Judge Fleischer for a little bit and see what's up in his court.
I'm sorry, that's the Fiona, Judge. 2530346.
That's the newest theft case then. Yes, and then all other three ones are being dismissed.
Yes, sir.
Okay.
Do you want me to stick around for the other?
Please, we'll do it next after this plea.
Oh, Katia, we talked on the phone briefly. I can't even remember the guy's name. The trial up there in Mass, Judge Cannoni has that big trial, the Brian Walsh trial. She's the judge. And so Brian Walsh wants access to the
Mr. Jones.
Come on, Joe. How you doing?
Karen Reed text messages because Proctor was the investigator on that as well.
Not too good. But
crazy.
I'll be able to manage to make it.
Yet you keep picking up case after case, and now you worked yourself in where you've got 4 open cases. What's it going to take, man?
Hey, Judge, you won't see me anymore.
If I had one strand of hair for every time I heard that, I would have a full head. I'd look so good with the hair I have. Oh my goodness. I'd be a rock star. If I had one strand every single time.
I understand, Judge.
Are you homeless?
No, sir. I had just lost my job, but I had got, hired back, so I won't be coming here, honestly.
There's another way.
Yes,
I'm going to tell you now, Mr. Jones, the days of catch and release are over. Yes, I'm not going to do this where you keep picking cases up, time served, keep picking cases up, time served. At some point, what I'm going to do, and if you don't believe me, ask them. I will not do anything else. We will set you up for a TRAS. And if they tell me that you got to do residential or some kind of dual diagnosis residential treatment, I'm going to do it. But I'm done with catch and release.
Yes, sir.
You understand me? So the next time you come back, you might be staying with me for some time.
Yes, sir.
You're charged with 2 counts of theft, a criminal trespass, and the possession of marijuana. The agreement that you have worked out is they're going to dismiss 3 of the cases, and you're pleading guilty to 1 theft. The other thing that you need to understand is that theft cases are enhanceable offenses, meaning that if you continue to pick them up on your 3rd, you're looking at a felony offense years instead of days.
Yes, sir.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Is this what you want to do?
Yes.
How do you plead to the offense, sir?
He looks at his attorney.
I will find you guilty, sentence you to 30 days in jail. I will give you credit for the 13 days that you've done. I will roll your court costs so you won't owe anything. Good luck to you, sir. Take care. Okay. You're good.
Thank you, Your Honor.
Thank you.
2 more weeks in jail, then he's out.
Sorry. I confirm with pretrial judge, he has had 7 negative P tests, and he's peeing again today for 8th test since April.
If he's negative today, then we'll do.
Can we call them
judge.
drug tests
Thank you.
instead of pee tests? He's peeing later again today. Most of us should be peeing later today. Oh my goodness. Toyo Toys.
Cruz Hernandez. Tú eres la mamá. Ven, por favor.
Okay. Phil, we're working on the paperwork for that one right now. I've actually got it pulled up right here. Hang on.
I understand that there was a conflict with the other lawyer. So I have let the other lawyer withdraw. I am now going to appoint you a new lawyer. I don't want conflicts to continue to arise. If conflicts continue to arise, then that means there's something wrong with then I will at that point be out of lawyers and you will be forced to hire your own lawyer. I want you to understand, Mr. Cruz, I do not want you out in the middle of the night. And I'm going to put an ankle monitor so I know where you are at all times. You are required to take your medication as ordered by a doctor. Is he under a doctor's care?
Thank you. Yes, yes.
I'm not talking to you. I'm talking to your mom. Is he under a doctor's care?
Just for the moment.
How often does he go to the doctor?
From Luis, the interpreter.
Tengo un tratamiento por 7 días y tengo que ir a recoger un tratamiento médico por esta vez. Y de ahí tengo que ir a citas y a citas.
No, the other one. That's it.
Todavía no.
It happened earlier while you were gone.
We're missing an interpreter.
Okay, so what I'm gonna have you guys do now is I'm gonna have you take a seat and then I'm gonna have a lawyer wait and talk to you guys, okay? Do not leave until we have the lawyer come talk to you, okay? Please. Victoria.
Victoria, bring me my Skittles. All right, jumping now to Judge Stephanie Boyd in Bexar County, Texas.
Yeah, his criminal history consists of possession of a marijuana, where he received 6 days in the Bexar County Jail. Then we have this.
Has he been in any car commercials? This guy reminds me of somebody.
So
maybe it's the
I'll hear
hairstyle.
argument state.
State is silent.
Yeah.
I will say though, Judge, that again, based off stipulations, again, he brought a gun to where no one else responded. He also shot at police were approaching us. Stipulations, again, danger to the community, is making an argument between neighbors and especially who had just reported his death. That was what the issue was.
He does.
All right.
Remind me of the
Defense,
caveman and the Geico
the state
commercial.
is silent other than fact issues. So is there anything you wish to add?
I don't think there's anything further to clarify, Your Honor.
All right. So this is what I'll do. Mr. Rowley, I can sentence you to deferred adjudication, in which case it will be for the full 10 years. You will not be released from the Bexar County Jail today because I will be sentencing you to ISF, or I can sentence you to 5 years in the prison. Those are your two options.
Ouch. Do you want prison or 10 years probation?
ISO.
Hmm?
Take ISO.
All right. And then I see that there was a request for mental health evaluation as well. So we do have mental health issues that are happening in this case as well. And until we can have placements for people who have mental health issues, this is the only thing that the court can do. So the court will sentence you to 10 years deferred adjudication. And counsel, normally I don't do this, but he does need to pay the $1,000 for the family moving. So there's going to be $1,000 restitution. And that's to Frank Hernandez. You're not allowed to visit, to go on the streets of that apartment complex. So there's to be no contact with the Conley Apartments at 5300 Northwest Loop 410. There's to be regular reporting by Zoom or in person. There's to be ISF cognitive, proof of employment within 30 days of release, no employment as a home healthcare provider or with minors, anger management. We're going to do GPS, waive fees, and that will be for tracking. That way we'll know where you are at all times. You understand? There's to be regular reporting. Sorry, I already did regular reporting. There's going to be field visits, 1 time per month until further notice. 200 hours of community service restitution. I'm going to order parenting classes. Once you completed parenting classes, that will be deemed satisfied. There's to be no unsupervised contact with minors. Take in consideration 2024 CR 006874, 2024 CR 006881. No contact with Frank Hernandez, Frank Coronado, Lily Beth Huerta. Huerta. There's a $2,000 fine that will be probated. And counts 1 and count 2 will run concurrently. Let me see what the TAP evaluation says. And there's, upon release, there's going to be 90 sober meetings in 90 days. Probation, is there anything else?
Judge, did you mention UA?
Thank you. Regular random UAs or the patch? Anything else, probation? Is there anything else that you need? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights Appeal with your attorney? Did you understand it and sign it? Sorry? Because this is a plea, because I followed your plea, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And you're not allowed to possess any weapons or ammunition. Do you understand? All right. We can go off the record. Here's the thing. If you are revoked off this probation, you're looking at 20 years in the prison. Do you understand? Not a cap of 7, but 20. Do you understand? All right. Good luck to you. Just stand over the side. I believe there is victim.
There's victim impact. Just a second here, trying to get some different feeds running. Trying to see what's going on with Cedric Simpson. What's up here, guys? What's up here, huh? I thought this guy was doing like an unboxing video earlier. Just reading what he's saying with his mouth. He's not happy. Donald, we can hear you.
Pretty much, yeah. That's a good. Actually, it's lack of memory.
Bless you, Don.
For the first time ever.
Very noisy courtroom as they get started.
Thank you. Or you can say lack of medication.
Part doesn't sound too good.
Well, I mean, that's generally what it is, but you can say lack of.
Okay.
So that's just fine. Yeah, you will have to say that
Okay.
when he asks, basically for the no contest legal action.
The new lawyers are getting
And I mean, you get the member, you could say that, but I mean, you can say both.
I've done that.
Because you just don't know.
In this case,
Correct. So, yeah.
All right. 1480, Court County of Washington, State of Michigan is now back in session. The Honorable Judge Day Cedric Simpson preside.
You may be seated.
Roro, thank you for gifting 5 memberships. Super generous of you. Thank you.
Court does call the case of the People versus Clinton Berry.
Governor Michael Vincent on behalf of Clinton Berry. State your name for the judge.
Clinton Michael Berry.
Thank you, sir.
All right. Farmers Market.
Your Honor, we need an
bacon,
adjournment
eggs.
for trying to resolve the case.
You don't have help with you today.
I certainly do.
Yeah.
Love this lawyer.
Good afternoon, Your Honor.
Good afternoon. Did you write this yourself?
No. The handwriting, maybe.
Yeah. That's not her handwriting. Because I can hardly read this that you did this. All right. How much time did you need?
2 weeks.
It's 2 weeks will work.
Will the 24th work? That'd be 3.
Yes.
Nice of you to be included in the conversation, Mr. Benson.
I know my place, Your Honor.
Yeah.
Been married a long time.
You just shut right up. October 24th, 2024, 9 a.m. or as your invite indicates. Bond will continue.
Make it fun.
Donald has some
Well, Your
anxiety
Honor, one
going
thing,
on.
he's got a tether on
Yes.
to avoid going to leave a lady's house who's a complainant. And I don't believe there's been any violation. He's an over the road trucker. He goes out of state. I don't think there's been any bond violations. He's worked it out with community corrections when he's out of state. He drives the truck, and frankly, the tether gets in the way of driving the truck.
Oh. Have you talked to the prosecutor about it?
No.
You should do that.
Because I just remembered it right now. I don't think there's been any complaints or anything. I don't think.
Well, yeah, but I don't know the entirety of the circumstances. And they're not looking at you.
Sorry,
No, what I was going to do was I was going to deny your request and have you talk to the prosecutor. If you guys work something out, that's fine. But
I would like the tether to remain until our next PCC, to be honest.
All right.
That would be my.
Okay. Yeah. No, that's fine.
All right.
All right.
I'll deny it this time. Thank you.
Joshua, What's that shirt say?
I'm trying to sneak something in. Court closed case, people versus Russell. Exo, is it XOB?
Dawn Farm, Stony Creek.
Your Honor, we need a adjournment on this for
Company
further
shirt.
discovery. We're asking for the radio traffic approximately 20 minutes before the traffic stop. There's some issues about entrapment that may or may not be there.
Issues of entrapment.
Your name, sir?
Russell Exelby.
Michael Vincent on behalf of Russell Exelby.
The 24th work? Well, I know that works because I just asked her
Yes.
5 minutes ago.
Yes, assuming we get the
Right. I just want to make sure I give you enough time to try to work all that out. October 24th, 2024, 9 a.m. Bond continued.
Just a call.
Checking his calendar. We just did that. Court calls the case. People versus Jacob Mohammed. Is it Colasar?
Michael Vincent on behalf of Mr. Mohammed Kolsar. We need a prelim date for this.
All discovery. Your name?
Jacob Mohammed Colasar.
All this discovery is complete.
Yes.
People have their witnesses available the 15th.
If possible, I ask if we could go to the next stage. The defendant is not in custody. This is an armed robbery case.
Any objection on your part? By going to the 22nd.
That date works for him, Your Honor.
All right. So I guess there's no objection. Preliminary examination in person, October 22nd, 2024.
Thank you, Reverend.
9 a.m.
That makes sense.
Before a judge. Where are you going?
Oh, no, stay.
Sorry. Before Judge Washington.
Thank you.
Bond will continue.
Now you can.
Now you may go. All right. Thank you. Court calls the case People versus Marcus Sanders.
Ready, Judge. Assistant Public Defender on behalf of Mr. Marcus Sanders. Mr. Sanders, please state your name for the record.
Marcus Terrell Sanders.
Thank you.
Thank you, Judge. As you recall, we were here a couple weeks ago trying to figure out the Lara issue as it relates to Mr. Sanders' professional license.
Yes, I remember.
I did have a chance to talk to Ms. Blanche. She made us a very reasonable offer. Mr. Sanders would like to take a little time to consider that. We can come back in a week or two.
An offer that won't cause problems with Lara.
We think it will cause, it won't cause them, or will be much less severe than any issues with the more serious charges. And he does have a bond request after this, Your Honor.
Of course.
Travel Cause Conference, October 17th, 2024, 9 a.m. as to your bond request.
Thank you, Judge. Mr. Sanders is on a personal bond, Your Honor. However, he would like to leave the state of Michigan, and he is not currently allowed to leave the state of Michigan.
That's right.
Yes, Judge. His sister is having her 35th birthday party.
Having what?
Her 35th birthday party. It is a
mine's next week.
I know, Judge.
Hey, we'll sing to the judge.
It is a cruise,
So
and it will
Sarah's,
not
right?
be in the
Sarah
state or in the states. So he is requesting permission to go to the party. I don't believe he's missed any court dates. I don't believe he's had any issues.
It's a cruise to where?
Bahamas, Nassau.
Response from the people.
I'm just concerned, Judge, obviously it's the probation first, Stevie second, A and B. Just looking out on bond, but I'll leave the discretion of court.
What are the travel dates?
It will be October 9th through October 15th.
That includes the travel days back.
Correct.
Leaving the state of Michigan.
That's some birthday
be
party.
back in Michigan.
9th through the 15th.
Will indicate defendant may travel to the Bahamas. October 9th through October 15th inclusive.
Thank you very much, Judge.
All right. Thank you.
Thank you.
The next date of that,
Is October 17th. Bond continue. Court calls the case of the people versus Rebecca Schilling.
People.
Good afternoon, Your Honor. Hannah Mackey on behalf of Mr. Schilling.
Oh,
Schilling, please state your name for the record.
Your Honor, I'm Rebecca Schilling.
good afternoon.
Your Honor, we have reached an agreement in this case whereupon the defendant is going to plead guilty, currently charged, sorry, should we plead no contest, currently charged count 2, operating while intoxicated. Count 1, fleeing and eluding in the 4th degree will be dismissed.
Is that a correct statement?
Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
State your name.
Rebecca Schilling.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of operating while intoxicated.
That's correct.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized. Also could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do.
All right. Do you understand what a no contest plea is?
I do.
All right. 2 things about it I have to make sure that you understand. First thing I need you to understand is it means that you're not further desirous or wanting to contest this charge. You understand that?
Correct.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Counsel, basis for the no contest plea.
Lack of memory, sir. The event happened 4 years ago.
So, ma'am, to that charge, how do you plead?
I plead no contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form. Is that correct?
I did.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead no contest?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
I am, Your Honor.
and of your own free will.
I am.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 205730. Any objection to the court having reviewed that report?
None from the people. Thank you, Your Honor.
None, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report, as well as alcohol screening and assessment through Von Swartz, is ordered. Sentencing in this matter will be October 23rd, 2024, 9 a.m. before me. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Ma'am, on your way out, you can stop by my probation department and get you started on the process. They're on the left-hand side down the hall.
Thank you, Your Honor.
Thank you. Court does call the case. People versus Jovan Smith.
Testimony from people.
Count over water assistant public defender on behalf of Mr. Smith.
Good afternoon, Your Honor.
Good afternoon.
Jovan Smith. Hands in your pocket.
I'd be asking to adjourn the probable cause conference 2 to 3 weeks. I'm still, there's still some discovery that's outstanding. I'm told that the prosecutor has that. I should have it very soon. And I would ask to address the condition of bond.
Probable cause conference, October 17th, 2024, 9 a.m. Yes, that's the bond.
My client is a football player at Community Christian College, and he has, I think, 6 games left in the season. One of those games is in Atlanta, Georgia. One is in New York City. So I'd be asking for the court's permission for him to leave the state to travel to those games. Additionally, I'd be asking for the court to allow either the scram tether to be removed Friday before and then put back on Monday with an ETG test.
What's he been doing all season?
He hasn't been playing.
So what is he? Is he set to play these games? I guess I'm trying to figure out what changed.
He's been getting me documentation to verify that he's on the team. So I wouldn't make the motion to amend his bond until I was given at least some verification. So he's presented me with his class schedule,
Verify he's on the team.
His school ID, his screenshots from his the computer system that they use to communicate with the rest of the team, his schedule, his recruitment information. So now that I have that, I was comfortable making the motion.
I guess I'm just trying to figure out. He's on the team. Could have had that to you at any point in time. Hasn't been playing. What is now causing him to play now?
Well, we're asking. I don't understand the question, Judge. We're asking now because now I have the information to ask. He asked me about this weeks ago. I didn't have the verification. So he's been asking for permission to play. I wouldn't bring it to the court until I had independent verification.
So he sat out, what, 4 weeks, 5 weeks of the season, has 6 weeks left, and now is going to play. That's what I'm getting at.
That's up, whether he's going to play or not is up to his coach, but I'm asking the court for permission so that he can be eligible to do that.
Okay.
Can I respond, Your Honor?
Yeah, go ahead.
So court eligible to play? Sorry.
This is an OWI causing death case, so it appears to the people that the defendant is at liberty at all and has a scram tether is frankly quite a gift, given the facts of the case and the circumstances surrounding it. Your Honor, the people are opposed to any removal of that scram tether at this time. It does not seem appropriate to allow the defendant to do that. We would ask the court to deny this request. I just was able to receive the MSP lab report, and I just showed it to defense counsel after this case was called, so he hasn't had the opportunity to discuss it with his client yet. But the people are now able to tell the court that the MSP lab report reflects that the defendant's VAC at the time of the crash and death was 0.186.
Too high. 0.08 is the legal limit.
I just am trying to understand. If I'm the coach of a team, I got a player, hasn't played half the season. Something has to change that says now this person is going to play.
First string got injured.
Not just that he provided the information regarding that to counsel.
But it's my understanding he's been eligible to play as far as his coach is concerned the entire time. What he needs is the court's permission. I believe he has been practicing. Is that correct? Have you played in any home games?
Yes.
So he has played. He just hasn't been able to travel. So at the very least, Judge, if the court's unwilling to remove the tether, I would at least ask if the court would allow him permission to leave the state there are actually 3 out-of-state games. There is one this coming weekend in South Carolina.
I may allow him to leave the state. I'm not removing the tether. I may allow him to leave the state, but I'm going to have to see a schedule. So understand this. I'm going to deny the motion. However, counsel, I would allow him to leave the state to play.
Judge, I can show the court a copy of the schedule right now.
I'm not going to do it right now. Prepare me an order with the dates that he's leaving. Get prosecutor to stipulate to those being the dates on the football schedule, and the court will sign off.
Thank you.
Wow.
Is there adjourned date?
17th. Thank you.
Thank you. Have a good day, Your Honor.
Thank you. Court calls the case, People versus Simeon Spalding.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Spalding. And Mr. Spalding, could you state your full name?
Beyond spotting.
Your Honor,
Dressed
we
appropriately.
are requesting today an adjournment of a few weeks. I did just meet Mr. Spalding this morning, and he'd like a chance to both review the police report and the media discovery in this file before he makes a decision about what he'd like to do going forward.
October 24th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Sloth Life, thank you for gifting a membership. It's awesome. We're about to jump up to Thurston, Washington.
Court
Josh.
calls case people versus Joshua Stanky.
Not that Josh. Josh has teased us with something. I have no idea what it is.
Assistant
But
Public
he's never
Defender
let us
Natalie
astray
Pate with and
before.
on behalf of Mr. Joshua Steinke, who is present via Zoom from Don Farm. Sir, can you please unmute and state your name for the record?
No, unmute and then state your name.
Here. You might have to turn up your microphone. Can't hear you.
Can you hear me now?
Hello, can you hear me now?
Yes, sure can. Yeah,
Awesome.
you came right through. Get
I
right
was
through.
got scared for a second. Hi, my name is Joshua Steinke.
Okay, very good. All right, what are you doing?
Thank you, Your Honor. We're respectfully requesting an adjournment. Mr. Steinke is in Don Farm. I did receive word from the people last night that there is no misdemeanor offer in this file, and I would like to further discuss next steps with Mr. Steinke.
Probable cause conference, October 17th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Mr. Steinke.
Court calls case people versus Keith Stewart.
Brian Bowling on behalf of Mr. Stewart. Can you state your name for the record, please? Chief Stewart.
All right. You'd like an adjournment for continued payment of restitution?
That's correct, Judge.
How far along on the restitution is he at this point?
He's paid $300 at this point in time. My understanding is he said within 30 days, he should have probably half of it paid. So we'll leave
Half of the total amount of
That's
restitution?
correct.
Probable cause conference, November 7th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case people versus Nicholas Drunk.
Drunk is the last name.
Anecdote Water Assistant Public Defender on behalf of Mr. Strong.
Treva is doing the one eye appearance.
Mr. Strong, would you please state your name for the record?
Nicholas Drunk. Thank you.
Your Honor, that's set the matter for preliminary examination.
Discovery is complete.
To my knowledge.
People have their witnesses available the 15th. Preliminary examination will be set October 15th, 2024, 9 a.m. That is before Judge Valvo.
How do you have to hold your phone so
Bond
that
will continue.
Thank you, Your Honor.
your only one eye is visible in the corner of the screen?
Court calls case people
I
versus
need to
William
try
Sumler.
this. I can do my selfie camera really quickly. Try to figure it out.
Public Defender Hannah Apple appearing on behalf of Mr. Sumler. I don't believe. Your Honor, unless
not
he
even
appears on
comfortable.
Zoom, I have not had an opportunity to speak with Mr. Sumler. I haven't had contact with him.
Sumler? Not there.
I don't think he's there.
Bench warrant will issue for defendant's failure to appear. Bond will be set in at 10,000 cash surety.
I got it.
Court calls the case, the people versus Abudale Silla.
Appellate Silla. Water Assistant Public Defender, Your Honor, we have had no contact with Mr. Silla. He's not currently present in court. I have no further information.
Bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount. Bond will be set in the amount of 10,000 cash surety.
Thank you, Your Honor.
That warrant will issue immediately. Court calls case People versus Vershawn Vincent.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vincent. Your Honor, who should be on Zoom.
Vincent?
Yes, I'm here. I'm trying to undo the camera. Can you hear me?
Yeah, I can hear you.
Or I'm
We're
trying
waiting
to put
for
the
your,
camera.
we're waiting for your camera.
I think Treba is laying.
And Your Honor, while Mr. Vincent figures out his camera, we are asking for an adjournment to provide some mitigation to the court, or I'm sorry, to this matter.
Next time he needs to have his camera available. October 24th, 2024, 9 a.m. Bond continued.
Ooh, we got
Thank you. You're all set, Mr. Vincent. I'll call you.
Hope we heard.
Court calls case of the People versus Alan Ward.
Ashley Lonnie for the people.
Good afternoon, Your Honor. Alexis, attorney on behalf of Mr. Ward. I've left a voicemail, sent an email. I have no further explanation for his failure to appear.
Bench warrant.
For the record, I'd be requesting an adjournment.
Of course. Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Dantes Williams.
Oh, Donald thought it was him. He's like, Don. Oh, no. Does he have pizza tattooed on his hand? Is that a pizza?
Jessica Blanchard.
Oh, no, it's a folded flag. Folded American flag.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Williams. And Mr. Williams, could you state your full name?
It's just cruel to have
Marquis
pizza.
Bernard Williams.
All of that? Okay.
Yes, my granddad.
All right. Okay. Thank
And
you.
Your Honor, at this time, we are requesting a preliminary examination date, and also, to the best of my knowledge, discovery is complete at this time.
People would have their witnesses available the 15th.
We'll do our best, Your Honor.
Preliminary examination in person, October 15th, 2024, 9 a.m. That's before Judge Barr. Bond will continue.
Thank you.
Thank you. Court calls the case People versus Donald Wilma.
Here we go.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Wilmoth. Will you please state your name for the record?
Donald Wilmoth.
Your Honor, we are asking for a brief adjournment. There is a plea form in the file. I'd like it to remain in the file. Mr. Wilmoth is anticipating to accept the offer. He just had a few more questions, so make sure that we resolve those.
Probable cause conference, October 17th, 2024, 9 a.m. Bond continue.
Thank you. Your Honor, may he continue to appear via Zoom? He resides in Mississippi.
He resides where?
In Mississippi.
Down in Mississippi?
Yes, sir. I drive a truck. I was just happened to have a load there. It was unexpected too. I just
Gotcha. Okay. Yes, he can appear via Zoom.
Thank you, Your
I
Honor.
should make him drive his truck back up here. No, I won't.
Thank you so much.
Okay. Thank you, sir.
Thank you, sir.
It's like, I never want to go to Michigan again. Whatever it was that happened.
That's it. Mr. Simon's arrived.
Baby Bear.
Here, Your Honor, yes.
Thank you. I love Baby Bear sent me cowboy candy before.
That wasn't a question. It was an observation.
It's candied
It is a very
jalapeno
astute
peppers.
observation,
Oh,
Your Honor.
so good. I can't wait. I will be watching for him.
All right. Clerk stands in recess.
All right.
Really quickly, let's see. Oh, that's not it. Why? Hold tight. Hold tight. Sexy body. Do you see that? Now I have to explain what's on my desktop. This is a workout video, and it was like a joke. I renamed it. I can't show you. I can't show you because it's copyright. But it's a Jessica. I can't remember her name. It's my wife's favorite workout video, and she had it on DVD, and the DVD was getting scratched because she was playing it a lot. She likes to use that video for exercise, and it's the Mrs. RA will vouch for this. Next time she's in here, I have no concerns whatsoever. She's going to back me up 100%. But I ripped a copy for our own personal use so that I could have it on the computer so she didn't have to load the DVD every time. She wanted to use it. And so that we put it on, I think, on all of our computers. So whatever computer she wants to use to exercise in the morning, she can pull that up. Yeah, you don't have to believe me because Mrs. RA will back me up on this one, so I'm good. Take it to Mrs. RA. She knows what it is. Here's what I was trying for before I tried to I got myself in a corner. Let's see, workspace, video clean feed on BDMI, HDMI. Okay, this was the background with Don. I think on his hand, I think that's a folded American flag. I think that's what it is. Like a triangle folded flag. I don't see Superman in there. But anyway. That's where we're going there. Let's see. Tariba is now fully with us, although she is still sleeping. Not sure what's going on there. Let's see. Judge Fleischer is still in session, so let's jump back over to Judge Fleischer now.
Immigration will put a detainer on you, and you will sit in jail for 6 to 9 months waiting for immigration to do whatever they're going to do. Are you a citizen of the United States?
No.
Are you in this country with or without permission?
Sin permiso, con permiso, pero está vencido.
So you're not with permission. You must be on your best behavior. You have a lot to lose. Once you get an immigration detainer, you will not get out. Do you understand?
Yes.
I'm sending in for a drug test now.
Yes, sir. If I may.
Test now.
Yes, sir. If I may.
Please.
Judge, he will come back positive for Restitution and active ingredients. I was given, or actually shown, the prescription for that. It is used to treat the symptoms of schizophrenia. He would also come back positive for Wafacine, I believe, and that's also used to treat high blood pressure and also ADHD. So he is under medical care of Dr.
I understand.
Stephanie Ding, D-I-N-G.
Bring the mom up here.
United Health, Harris County Psychiatric Center. So, just so the court's aware that he will come back positive for
I will never hurt or jail anyone that is being seen by a doctor and taking medicine prescribed by a legitimate doctor. But if you are using marijuana, then you're going to go to jail. You are not allowed to use marijuana, alcohol, or any other illegal drugs. Only things that are prescribed by a doctor. So if you're using marijuana, you better not. I'm going to send you for a drug test now, and I'm going to drug test you like crazy. Do you understand? Okay. I want to know what is going to come back tomorrow.
Yes, sir.
Like I said, if for the medicine that he's prescribed, I'm okay with it. Anything else?
Old one.
No, sir. That's it.
Yes, sir.
Eyes are always everywhere watching you.
No, it's live.
Be careful what you do. Be careful what you say. Because if you run into the wrong person, it will not go well for you.
Yes, sir.
Okay. All right. See you tomorrow. Mr. Fritter, why are you still here? No, I don't think so.
Mr. Fritter, leave my court.
Abel, you're representing Mr. Fritter, right?
Yes, sir.
Yeah, I think that we're good to go.
Yeah, she told me to come back with a trial.
Okay,
You did.
yeah. I don't remember what the.
You did.
Did you see by chance? No.
It's he just came back probably Tuesday first. So he's gonna come back probably today again.
Well, okay, let me just make sure there's nothing else and then we'll cut them loose. Yeah.
This judge does not wear a robe. He normally wears a bow tie, and lately he started favoring the more traditional ties. He has a couple different pairs of glasses he wears. This is one of the rounder pairs.
Bob, come on up.
Oh, I have to go do a plea right over there. I'll be right back.
He's got 2 courtrooms. He is fluent in Spanish. He brings a translator, though, often. Let's check in on Tariba. Still waiting for Judge Simpson. She is most definitely laying down. That is like fully reclined on her side. I think that's a Minky Couture blanket. Nice soft blanket. Not sure if it's for comfort or for warmth. They do a little more comfort than warmth. She's trapped in the Zoom. Send help. Blink twice if you need help. Tariba. Tabria. Sorry, Tabria. Myron comes in and says, I can help. That got Tariba's attention. Nope. She said, no, thank you. I like it when the participants just start talking to each other. If she has a legitimate reason to be unwell, then the judge will be completely understanding. But if she just happens to be tired and sleeping in, what's in that bottle? Looks like Fiji water. Fiji water for the win. Had that been a 40, things would not go as well for Myron. The judge will be understanding if somebody's not well. He always is. But if you're just laying down because you're too lazy to get up, judge will call that one out. Not sure if the blinged out look is the best look for court, especially if, say, like there are court fines involved and you say you can't pay. The judge is going to look at that and be like, really? Really? You're wearing like 6 ounces. Oh, we've got a call. We have a call. Kid you not. Hello? Hello?
Hello. Yes, my name is Adam from Senior Benefits. How are you doing today?
I'm doing well.
All right. We are calling you to review your Medicare options for the year 2024. So I believe you have Medicare Part A and B, right?
I need someone to help me with it to understand what I have.
Do you have a white Medicare card with red and blue lines on it?
Yeah, I think I do.
Okay, and just to make sure you can qualify for some additional benefits, how young are you? What is your age?
67.
Okay, sir. So that's all done from my side. Let me connect your call with my senior supervisor who will further assist you. Hold on a second.
Okay.
Good day. This is Jessica on a recorded line. How are you?
Hi, Jessica. I'm doing well.
Okay. This call is about your Medicare benefits and savings you may qualify for. So I believe you have Medicare Part A and B?
The white card?
No, it's a red, white, and blue card.
I have to look. I have it somewhere.
No problem. How old are you?
67.
67. Then you should have. So you don't remember using Medicare?
I don't remember what I had for breakfast this morning.
Oh, then you have Alzheimer's and I cannot deal with it.
Why is that? Hello? Jessica? Hello? Why are you hanging up on me? I got Alzheimer's and she cannot deal with that, apparently. Okay, so mental note, next time I have to remember that I can't have Alzheimer's. She won't help you if you legit have Alzheimer's. Part of me says good, okay? But part of me also says, yeah, I don't know. I lost Jessica. We'll try it again. That's the furthest we've ever got with the Medicaid one. So apparently I need a red, white, and blue card. When they ask me next time, I'll say what color is the card, and that I can't read the words on it. I'll just go with the color. I'll do that. Okay. She just diagnosed me over the phone on a recorded line with Alzheimer's because I couldn't remember what I had for breakfast. If only it were that easy to diagnose medical conditions. Teledoc would be much more popular than it is. You need a patriotic card. Oh, I can say I've got the red, white, and blue one, like the flag. And they'll be like, yeah, that's the one. So it's I use that at the grocery store. It's my Discover card. I'll do that. I'll do that line and see if that works. You would know if you have Medicare. Apparently 67 is a good age. I wanted to be over the retirement age, but I didn't know how far over before they'd say, yeah, that's too old. Bite me. Thank you very much. I see somebody's, speaking of credit cards, Buttercup has stolen Bite Me's credit card. Medicare gives you a stipend per month for expenses. By the time by the time I'm like ready for Medicare, I will know so much about it from all these calls. For the non-US people, what is this scam? I don't know what the end result is because I'm not in the category that currently participates in Medicare. I'm not of the eligible age, I believe. 72 is a good age. Need a voice changer. I do also desperately. I know they make some cool ones for singing music that can like change the octave of my pitch. They pretty much just scam you out of money. I'm waiting to be added to Medicare because fully disabled and it's a nightmare. If they call you again, give them my number, says Wendy. Wendy, I'm sorry. I believe these individuals that are calling are not with Medicare. They're with a company that is trying to charge Medicare money in your name, like on your account, is my understanding. I need a voice changer because my fake voices don't do very well. Did I tell you the story about the time I answered the phone thinking it was a prank phone call, and it wasn't, and I was using a silly voice, and I was like 2 or 3 questions into the call before I realized that it was somebody who I was actually expecting to speak with, and I couldn't at that point go back to my normal voice because then it would be like really awkward. and it was somebody I didn't need to speak with regularly, but I did need to engage with. Do you remember that story? I'm trying to remember who it was that I had asked for the call. I'm like, hello. I answered this little, and I'm using this voice. Yeah, and then I'm like, oh crap, it's the call I've been waiting for, right? And I have to continue the conversation in the same voice, so that I don't make the guy think that I was. Yeah, I'm not a cat. Yeah. Sometimes I make stupid mistakes like that, but the police are going by. All right, you haven't heard that story. Okay, basically, that's it. I answered the call. I think I told it on a live stream a long time ago, but let's see. Where's still waiting for Simpson to come back. I think Judge Boyd bailed on us. Oh, Thurston County. We were going to go to Thurston County, right? Did I show Thurston County already? Where did I have it? Josh, you gave me something to show in Thurston County, and it was on camera 7 even. Let me go back. That wasn't it. I don't know where it went. Josh, I lost it. Hang on 1 second. I'll pull it up from Mod Chat again. Okay, you said 1 hour, 4 minutes, 11 seconds into this video. Here we go. Let's go here. Let's go here. This is Thurston County, Washington. Happened, I believe, the other day. And this is, once again, a recommendation of Josh Hutchins, one of our great mods. Maya docs. Which ones do you want? We haven't read Maya docs. Let me see what we can find. See what's out there. Thank you, Legally Blonde. Appreciate that. Still playing. Okay, we've got somebody. He's got the goatee braid. And
P, F, P, F, M. Mi amigo, presenta. Papeleo está en el Facebook. I subí por the serial money for all those who are poisoning the children too. And I put those for those who obey, not for those who are now obeying. Don't pretend to be something that you're not.
Mr. Valencia?
Yes.
Who are you talking to?
Oh, I thought you were right there. So I'm married to my beautiful wife. So I thought to her going to get her pregnant, and that's why I need to go over there because I'm preparing everything ready. So I need to come over there. Just got my beautiful wife. Name is Lian, pero ella Plasencia. El Dios de todas las diosas. Love you. All of them.
On this matter?
His wife's watching.
Okay.
Yeah.
Okay.
Ms. Langley, are you ready to
Yes. Yes.
All right.
Well, except for one issue. I'm having trouble with this thing.
Miss Langley, his lawyer, is here. Dental hygiene is important. Take care of it when you can. I'm not going to sit in the judge's chair. The judge is going to walk in just a minute. He just burped. There might be some mental issues here. I don't know. It sounded like he was, I don't know Spanish. It sounded like he thought his wife was watching and he was trying to say something to her. There was something about Facebook and I'm not going to skip ahead to when the judge comes in because this might be the good part. I think he might need some help. Miss Langley bails. Because of how I'm running this, let's see, well, my controls for upstream keyer, DVE, position, I can move myself manually. Here we go. I just don't have access to the other machine. Let's get a little smaller in case the judge does show up. This is why I love the Stream Deck. It can do everything I need to do. Just maybe not the same way. Are we paused? No, time's still moving forward. '23, 24. Okay, I'll just let it play. Josh, I'm trusting you on this one. I do think there might be, you can fast forward some. Okay, let's drag this forward just a tiny bit. Dental cleaning continues. I think he needs help. Just elbowed the screen or wiped the screen with his elbow. Okay, let's see how this starts.
County District Court is back in session.
Hola, amor. Hola, Gloria, presencia, P, F, F, M, F, M. Hello, mi amor.
Hello,
my Mr. Placencia Arvalo, I take it. Yes, hello. So, Ms. Langley, you've had a chance to talk?
Yes, I did.
I have, Your Honor.
Exactly.
Yes, they got the wrong case and everything that's been this week because I just got out of telecare. And I was in West Fargo and they got me right there and said, what's a trespass? Usually for a trespass, yes, made me sign a a piece of a sheet of paper, and this time the point right here is already been here like 72 hours, so I need to get it.
She wasn't talking to you, sir.
To my beautiful wife.
So let me talk to Ms. Langley. Thanks, Ms. Langley.
Thank you, Your Honor. So I've had an opportunity to talk to Mr. Placencia. I think I have two concerns. Although he remembers me and we've had some conversation, I'm not sure that I'm comfortable about his competency at this point, and he has had a history. Also, I'm not stipulating to probable cause. So,
okay, well, maybe that's the first thing to take out. So I'm going to talk to the prosecutor now, not you, sir, but I'm going to talk to the prosecutor. And Mr. Sharp, we got facts to support, to supply. All right. So, Mr. Sharp, you swear from the information I'll give all afternoon as to probable cause, truth, whole truth, and nothing but the truth?
I so swear, Your Honor.
Okay.
Okay, so this information comes from both the written report of Officer Mercer, the Lacey Police Department, and the written statement of Ms. Kunkel, who's the victim and witness of this case. Officer Mercer writes that on Friday, September 27th, 2024, in the afternoon, it looks like 1:20 in the afternoon, he was dispatched to a suspect described as walking through the parking lot at 4022 Pacific Avenue Southeast, leaning on people's cars and harassing people. He was described as a white male in his 20s, tall and heavy set, wearing a tan shirt.
My skin is brown, so I'm not white. So I'm sorry.
So it's really difficult to hear one person when another interrupts. So just try not to interrupt.
I'm not a white.
Try not to interrupt, sir. Let me just hear one person at a time. And I'm listening to the city prosecutor right now. Slow down. Let me hear from the city prosecutor, and then I'm going to hear the other side of things. So one person at a time. Mr. Sharp.
Thank you, Your Honor. Officer Mercer contacted Ms. Kunkel, who reported that the suspect had struck her vehicle with his elbow, denting the vehicle above the passenger side window frame. Officer was able to observe clearly a golf ball-sized dent above the passenger side rear window of the car. Officer Moore of the Lacey Police Department had located the suspect matching the description at the corner of Pacific Avenue Southeast and Slater-Kinney Road, which was nearby. Officer Mercer and Ms. Kunkel walked over where she had a clear view of the subject, and Ms. Kunkel plausibly identified him. The suspect, later identified as Mr. Placencia, was taken into custody without.
What don't you realize? You got pictures of that. I was in. Listen, there's a camera in West Fargo and Pacific.
Again, Mr. Placencia, let me just one person at a time, and then I'm going to turn over to your attorney. So hang on a second. Let Mr. Sharp finish.
I didn't fucking do any of that. I would remember.
Your Honor, in discussions with defense, there was a question about mens rea, and I think that's shored up by Ms. Kunkel's written statement. She writes that, and this is sworn under penalty of perjury. She did sign it. A man was harassing other drivers in the parking lot, trying to open doors and leaning on cars. He walked from 7-Eleven towards Mod Pizza, where I was working. He feigned a kick at my car at the driver's side front fender before walking to the other side of the door. He threw his elbow into the edge above my passenger's. I'm sorry, it's hard to read. My passenger side door.
Pictures and videos and evidence because somebody else is lying about it, and I got witnesses. There's some people that were driving right there. They can the best brightness cameras in those parking lots. So I wanted to see those proofs because that's not me. First of all, I'm not a white male. Second of all, I was in West Fargo.
Your Honor, I wonder if Mr. Placencia could be muted at least until I'm done with probable cause. Almost done though. Continuing with Ms. Kunkel's written statement, she reports that he had just thrown an elbow at the edge of the door. She writes that this time he struck and connected and left a golf ball sized dent. He then crossed to the back of the car, striking at the top of the trunk again with his elbow, but there's no damage I can initially see from that hit. And so the city's submission here is that with multiple strikes of the vehicle, that's a clear indicator of the necessary mens rea for a probable cause on malicious mischief, meaning malice, namely, this was not accidental with those 3 strikes.
And Ms. Langley, anything?
Well, along with the fact that I don't think we have an eyewitness, we have an identification of a white male, and I think he aptly points out he's Hispanic and looks Hispanic. And I'm not sure, perhaps that's enough for the purposes of probable cause, but but I'm not sure that he wasn't just flailing around and that he had any intent to cause any damage, and certainly that he was acting maliciously.
Brief response.
Mr. Sharp?
Ms. Kunkel did directly observe Mr. Placencia and identify him. So whatever description was given by dispatch is not really relevant at that point.
Well, in the light most favorable to the government, I do find there's enough evidence to set release conditions and potentially to consider, I don't know if the next step, Ms. Langley, you're concerned about filing an order, a request for an order under 1077.
And yeah, and it's very difficult, Your Honor. I know I wouldn't even think about it, except he has a history, and we go from pretty lucid conversations to suddenly strings of numbers and talking about his wife, and so I'm not totally sure. So I'm uncomfortable about that.
Right, and just as recently as June, in the city of Olympia, there was a finding of incompetence. And but then before that, in March, there was a finding of competence. So it's kind of, as we know, goes up and down and up and down. And I don't have the Olympia evaluation, obviously, because we're not the city of Olympia. So I don't know what the basis of their finding of lack of competency was in June. And we haven't seen Mr. Placencia Arevalo for a while.
Oh no, I clicked the wrong button. I'm sorry. We'll go back to that, shall we? We'll go back. Give me a minute. Oh man. Thurston County District Court. Okay, just one second. What camera can we bring in on this one? I need the phone is the problem. I need the phone to do a different thing, and that's where it was coming in at. Let's bring on camera 7. I think somebody's mowing my lawn. Thurston County District Courts. Lacey. Let's pick up where we left off here, if I can find it. Okay, I'm at the right spot. Let me see if I can pull this up here. This will actually be better for everybody because I think the image is going to be a little higher quality. Yep, 720 minimum. Okay, bring the audio on. See, look, we're back. We're back, almost as if we never missed anything. Sorry about that, guys. Let's see, we were right. Raised his hand.
She did sign it.
Okay, we got this part.
Elbow, but there's no damage I can initially see.
It looks Hispanic, and I'm not sure. I mean, perhaps that's enough for the purposes of probable cause, but I'm not sure that he wasn't just flailing around and that he had any intent to cause any damage, and certainly that he was acting maliciously.
Brief response.
Mr. Sharp?
Ms. Kunkel did directly observe Mr. Placencia and identify him. So whatever description was given by dispatch is not really relevant at that point.
Well, in the light most favorable to the government, I do find there's enough evidence to set release conditions and potentially to consider, I don't know if the next step, Ms. Langley, you're concerned about filing a a request for an order under 1077.
And yeah, and it's very difficult, Your Honor. I know I wouldn't even think about it, except he has a history, and we go from pretty lucid conversations to suddenly strings of numbers and talking about his wife, and so I'm not totally sure. So I'm uncomfortable about that.
Right, and just as recently as June, in the city of Olympia, there was a finding of incompetence. And but then before that, in March, there was a finding of competence. So it's kind of, as we know, goes up and down and up and down. And I don't have the Olympia evaluation, obviously, because we're not the city of Olympia. So I don't know what the basis of their finding of lack of competency was in June. And we haven't seen Mr. Placencia Arevalo for a while here. Actually, not very long.
Your Honor, given the fluid state of competency and Mr. Placencia demonstrating that through his history, city would suggest, despite there having been a recent evaluation, city would suggest ordering another one. Now, the city isn't easygoing about these evaluations. We often try to spare the Western State Hospital the expense, given how thinly they're stretched these days. But under these circumstances, the city would request an evaluation.
Just looking at the Olympia docket, looks like they did an in custody evaluation, and that came out in June. And it's been just and I think the city dismissed 2 cases, or at least 1 case in the meantime, based on that in August. And here we are again. So, Ms. Langley, I will grant a request for an order under RCW 1077. I mean, it kind of comes from all sides here, and I'm seeing the need for it as well. Between the 2 attorneys, I'll just need somebody to get that written up. I am going to hold Mr. Placencia Arevalo for that and set a court date quickly. Let's see. And if things change in the meantime, everyone knows how to get a hold of us, but we'll set this for the
Listen, I got my wife, I got my family. This was a trespass. This is not a white male. I'm Latino. Listen, if you find me unconfident for this, send me to telecare, because I don't want to be here. They don't feel me right here. My back hurts.
I understand. So we'll get this set for October 7th.
Just do it. Give me a call.
If something happens in the meantime, please let the court know. And then I'll look to the attorneys to get that into the court, I hope sometime this afternoon.
Yes, Your Honor.
Okay, all right. So that's all this afternoon, sir. We're going to have
again release,
Western State Hospital come in and talk with you.
All right, all right. So I get released, right?
No.
Well, we're not getting released.
We'll have Western State Hospital come talk to you.
What am I going to Western State Hospital? I want to go to Western State.
We're back in court in 2 weeks.
I need to get released. That's what I need to do. I didn't do any of that. I'm not a white male. I'm Latino. I don't hate anything. Why am I beheading cars? There's no reason for me to hate anybody.
No.
Those are false accusations. It was a trespass.
I know you disagree, but that's the decision of the court. And we're done with Mr. Placencia Arevalo. So it'll be the 14th, and if of course it comes in sooner, then they'll let us know.
He's not happy. I think the judge made the right call. I think he needs a medical evaluation. See if there's some mental health issues there. But sadly, as I've said before, jail is the worst place and the least effective place to get mental health treatment. Possibly the hospital could help. All right. we've had a couple requests for Maya documents, and I'm looking at this, and I just found, like, on the 25th of last month. Hey, can you get me like 3 water bottles? I might need them. On the 25th of this last month, there was a filing, motion sanctions filing. 193 pages. Sorry, I've still got the audio going on. I'll turn them off. 193 pages. Whoa. P. Diddy hires death penalty attorney. Did I get the link to the appellate docket? I've got the main case. Let's see. I've got the main case. We're talking 2018 CA 005321 NC. That's the case I'm dealing with. Is there another? Thank you. Thank you, my son. If we're going to read, I'm going to need some water. This one had a hole in it. Could I get one that's not defective? Thanks. All right, now I'm ready. I'm fully hydrated. All right. Let's see. Is the appellate docket the 2021 CA 001009 NC? Is it 1009? I think it's 1009. Let me try this one. Open link in new tab. How can anyone do that? I have the ability. I'll demonstrate this one time on air when when it's just a few of us friends. I have the ability to, like, imagine drinking out of the hose, right? Because as kids we could drink out of the hose. It was never bad for us when we were kids. Thank you. This one looks much better. You can just pour water in your mouth, and you don't want to put your mouth on the hose because that's disgusting. Right? The hose lays on the ground, worms and bugs crawl on it, but the water coming out of the hose is clean as when it fell from the sky or came out of the ground. And so I can pour water directly in my mouth and never close my mouth and just drink. And I didn't know other people couldn't do this. But yes, I can just drink water, just pouring it into my mouth with never closing my mouth. I can swallow with my mouth open, I guess. I don't know, is that like a life skill? Guess not. Maybe this is more of a podcast material. I would drown, says the other Jules. I would drown. Other people can't do that, says Justin Smith. It's a rare talent. It's not very well known. Yeah. All right. So I'm pulling up the docket here. I think we have. I think this is the right thing. I'm waiting for a confirmation to make sure I'm reading the right document. Here's the appellate link. This is docket entries. Trying to find the best place to view this. I've been asked to read this, but there's like 7,000 pages, and I need to know which set of pages you want read. The latest one on the appellate case says, by order of the court, appellee's notice of voluntary dismissal of cross appeal is granted, and the cross appeal is dismissed and the appeal remains pending. That's one of them. That's the latest on the appellate docket. On the appellate docket, there's the initial brief and the answer brief, 30th of September. Mathis, I need to teach you how to use my WeTransfer. You get the document and you send it to my WeTransfer, and then I just have it because this little website is not working for me. Initial brief. Notice order. I've got a brief. Answer, appendix to answer. I don't see an initial brief. Notice order brief. Okay. Mathis, I'm going to need some help. I don't know which one it is. The ones that you've just linked there, it tells me I can't view them. It's not able to view it on this app. I'm down for reading some Maya docs. And we have a couple. I mean, there's 193. There's a motion about the IJ. Let me skim through really quickly on. Let's do this one on camera 7 or 3 actually. Okay, let's bring this up on screen. We've got this guy here. This is in the regular case docket, not the appellate docket. This was filed, let's see, the plaintiff from Jack and Maya. So this is move this honorable court for an order granting plaintiff relief from in-court stipulations to withdraw 6 sanctions orders and a request for fees during the April 22nd hearing on sanctions hearing and to enter sanctions against the defendant. So they were given sanctions by the court. Includes denying all its sanctions motions for its duplicity and violating those stipulations by simply reasserting their motions in another forum. Okay. Let me scroll down and see what they're trying to get to here. This should not be taken lightly. Given the public attention in the media and the social media on this case, the defense has caused irreparable damage to the plaintiff's counsel. Let's see. I know you don't do email, but I sent you both the links. Okay, maybe that'll be. It's checking mail. It's downloading. There we go. 1 minute ago, I got these. Recovery Addict. Mathis briefs. Here's the link. Okay, we're gonna close this one down and pull up the ones that Mathis wants here in just 1 second. Okay, here's the first one. All right, first one. An appeal from the 12th Judicial Circuit Court. Initial brief of appellant. This is the long one. Okay, we've got a table of contents, which we're not going to read. Argument. Look at these pages. Mathis, this is 115 pages. We've got case law that's cited. A lot of case law. We've got federal law, other regulations, preliminary statements. Okay, we'll read this part. The brief uses these references, abbreviated names. Okay, this is who's who. Citations, unredacted record on appeal is cited as R. The unredacted transcript is T. Nature of the case. This appeal involves 3 judgments totaling $208 million stemming from 10-year-old Maya Kowalski's hospitalization at J. Hatch from October 2016 to January 2017 because DCF and J. Hatch suspected medical child abuse by Maya's mother, Beata Kowalski, that the last 91 days of Maya's 97-day hospitalization were under court-ordered DCF supervision at J. Hatch, and Ms. Kowalski did not enter the hospital. The trial court correctly ruled that J. Hatch properly reported suspected medical child abuse and was not responsible under Section 39 Florida statutes for the DCF proceedings or for keeping Maya hospitalized. Yet, plaintiffs repeatedly asked the jury to find J. Hatch liable for hospitalizing Maya. Asked the jury to find J. Hatch liable for hospitalizing Maya and enforcing the shelter order. The first judgment is based on Ms. Kowalski's suicide alone in her Venice home 3 months into Maya's hospitalization and 1 day after the dependency court hearing where the judge did not allow her to hug Maya. Minutes after the hearing ended, Mrs. Kowalski drafted a suicide note. Despite J. Hatch healthcare providers' limited contact with Mrs. Kowalski for almost 3 months before her suicide, plaintiff's 8th Amendment complaint included a wrongful death claim based on intentional infliction of emotional distress, alleging that J. Hatch committed intentional, atrocious conduct causing Mrs. Kowalski's extreme emotional distress that caused her suicide. The jury awarded $108 million, which the judge remitted to $66 million. J. Hatch found that no reported case that has gone to verdict on such a claim, which is the first of its kind. J. Hatch maintains that it should not have gone to verdict here. J. Hatch also maintains that no evidence established in this extreme and outrageous conduct or conduct done intentionally or recklessly to cause Ms. Kowalski's emotional distress or suicide. The second judgment is for Mr. Kowalski and includes claims for fraudulent billing and Maya's pre-majority medical expenses. Plaintiffs suggested the jury could award only nominal damages for fraud. Plaintiffs also argued over objection that non-economic damages could be measured hourly for each component of those damages and spread among all the claims. The jury awarded $5 million for fraud, which the judge reduced to $2. J. Hatch maintains that it was entitled to a redirected verdict, and the award shows the passion and prejudice that fueled every jury award. The jury also awarded Mr. Kowalski $1.5 million for Maya's medical bills relating to her intentional tort claims. J. Hatch maintains the plaintiffs presented no evidence of physical injuries, treatments, or bills for these claims. The court denied all post-trial relief. The third judgment is Maya's, totaling $143 million, including $50 million in punitive damages. This judgment involves 1 medical negligence and 6 intentional tort claims. J. Hatch maintains that it did not receive a fair trial on these claims, in part because of the prejudice created by allowing jurors to hear evidence related to the first 2 judgments. The trial court denied post-trial motions on these issues. Okay, so they're complaining about that, and we're going to scroll down to the whereas at the end. 193 pages later. Mathis, I think you're just doing this to wind me up. We are waiting for the boondocks to get dropped. Thank you, mods, for updating the pin. The judge has a couple documents he said will be filed by the end of the day. He is working today, even though the courts are on vacation in Florida. J. Hatch got an unfair trial. Good grief. Where's the Where's the summation at the end? Let's back up here just a little bit. Okay, so here are the three parts. Ready, right? 1, 2, and that ending is huge. The $50 million punitive damages judgment for 4 intentional torts is erroneous for multiple reasons. The court erred in submitting this claim to the jury. They want this whole thing overturned. Punitive damage awards were excessive. Conclusion on next page. For all these reasons, Appellant Johns Hopkins All Children's Hospital respectfully requests that this court reverse the final judgment and remand to the trial court with instructions to enter judgment in appellant's favor on the wrongful death and IIED claims and the first false imprisonment claim, and retry any remaining claims. That's signed by Derek Strikeletter, who was the attorney who was handling this. Okay, so that's one of them. Let's go to the link for the second one, which is the answer brief, which is, I believe, much more brief. Where's the table of contents? Nope, it's like 100 pages too, 102 pages. Okay, statement of the case and facts. The hospital omits necessary facts and fails to view those facts in the light most favorable to the Kowalskis. The Kowalskis therefore provide their own statement. Jack became the personal representative of his wife following her suicide. Jack is, and Beata was, the natural parent of Maya and Kyle. I said Beata. I meant Beata. I can't even remember if I'm saying that right now. When the events described below began, Maya was 9 years old, Kyle was 7. Diagnosis and early treatment. They document Maya's visits. So they're going through the entire case, the time frame. Second, and the report of child abuse. Dependency proceedings and shelter orders. They cover all of those. There's no way I can read these, Mathis. How do you feel about that?
The document reader.
Mathis.
Hello.
You sent me like 300 pages to read.
Yeah, but because they have like 50, 60 pages in the beginning. That's like just a summary of like 10 weeks trial. In this document, you can just skip to page 63 for the argument, and then read the sections about the individual legal topics that you find most interesting. I don't expect you to read everything. Like the summary of the facts, I think there can take them. We don't need a 60-page recap, but the legal argument is where it's very interesting.
63.
Like the sections has a header like in bold that says argument.
I hear you. I trust you. I'm just trying to get there. We're on 61, 62.
You know, there's buttons that let you skip to individual pages.
Not on my viewer.
Okay.
Let's see. Let me go back up to I'm in the response. Statement of the argument. It's on page 51 for me. Which?
Okay, yeah. So it's 54. Sorry, it's 64 out of 128, but the internal documents page number is 54.
There it is. Argument. Got it.
Yes.
I'm there now.
And then you can skip sections you don't find super interesting. They have this very descriptive headers.
All right. And you've already read all this, right?
Yes, and citations.
Okay. And the citations.
That I could find.
You read all the case laws.
I can't find cases from the 1800s.
Okay. I'll read this argument and we'll see what happens here.
Yeah, read some of the argument.
Well, thank you, Mathis. I'm not sure how much we can get through. All right. Thank you, my friend.
That's
Appreciate
okay.
it.
Have a great day.
You too. Bye.
Bye.
I hung up on him on accident. I didn't mean to. Sorry about that, Mathis. The final judgment comes to this court with the presumption of correctness, and the hospital bears the burden to show reversible error. The pretrial and post-trial orders show the trial court's careful and thorough analysis of the applicable law and its application to the issues. After dismissing with prejudice or granting summary judgment in the hospital's favor as to 21 claims, in several instances based on Chapter 39 immunity, the court conducted a fair and balanced trial on the remaining claims. The hospital maintained throughout that it did nothing wrong. The Kowalskis were not injured, at least not badly. It was only following DCF orders, and the jury and the trial court simply did not understand its case. The hospital now doubles down on those contentions, showing it still does not get how atrocious its conduct was. It seeks to relitigate factual issues the jury decided against it, such as whether it engaged in extreme and outrageous conduct, or whether it was deceptive in its billings. This is a good argument. Contrary to how appellate courts view facts after the verdict, the hospital either construes disputed facts in its favor or simply proclaims there was no evidence. None of these assertions is correct. The hospital arguments should be rejected and the final judgment affirmed. Part 1. The trial court correctly upheld the jury verdict for the IIED and the wrongful death claims for Beata. The standard of review is that the denial of a motion for a new trial that asserts its insufficiency of the evidence is reviewed for abuse of discretion. For the tort of intentional infliction of emotional distress, the question of whether conduct is in fact outrageous is one of law. Case law there. To determine if the outrageousness standard has been met, the court must evaluate the testimony in the light most favorable to the non-moving party, and every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party. If there are conflicts in the evidence or different reasonable inferences that may be drawn, the issue is factual and should be submitted to the jury. Where significant facts are disputed, whether outrageous conduct is intended to cause a person emotional distress or recklessly does so, is a question the jury may infer from the evidence. A denial of a summary judgment motion that asserts no genuine issues of material fact is reviewed de novo. All issues of fact should be construed in a light most favorable to the non-movement. So it continues on. Merits argument. The evidence showed the hospital engaged in conduct sufficiently outrageous to prove an IIED claim. As the Kowalskis inserted below, the outrageous conduct proving the claim is the 3-month effort to break Maya and her family via the campaign mounted by the hospital personnel to force a mother to confess to medical child abuse and force her seriously ill 10-year-old daughter to confess to a charade and implicate her mother. The trial court characterized the hospital's efforts as purposefully designed to destroy Maya's relationship with her mother. These efforts, none of which were required or authorized by Chapter 39, include the following: Maya's case false imprisonment, Maya's false imprisonment and battery, the hospital treating team's termination of Maya's prescribed medication, Beatty advising Jack to divorce Beata, Beatty's multiple batteries of Maya and other emotional damaging behaviors, the hospital's senseless refusal to allow Maya and Beata to communicate during what became the last 10 days of Beata's life. The evidence showed Beata knew about this torturous conduct, and it was the jury's province to infer this medical blackmail was intended to expose Beata's charade. The restatement of torts defines that outrageous conduct needed to prove the tort as generally the case is one in which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, "Outrageous!" And then you have especially outrageous. Outrageous more so than the conduct in either Winter Haven or Melet. This is interesting. He's saying that the case law that he's citing wasn't as extreme as what happened in Maya's case. He was like, this is the new maximum that we've ever seen in case law. But there's more. Hospital knew, and they continued to act that way. Another factor is the unequal position of the parties, or one has the power to affect the interests of the other. They talk about the photographs of Maya without her consent or with parental consent. Finally, there's a callous attitude of some hospital personnel to the Kowalski's circumstances. You got Dr. Tepa Sanchez suggested Maya might be better off without her mother. In her text response to Dr. Smith's insinuation that one of Maya's treating physicians should have trouble sleeping at night, Dr. Major responded, LOL, an abbreviation commonly understood to mean laughing out loud. Dr. Smith's text to Dr. Major 2 days after Beata's suicide ends with nothing more than craziest case ever, with 3 exclamation points. One can infer the hospital personnel considered this ordeal just another case, not a family tragedy they created due to their vendetta against the family for questioning the care they provided. Evidence showed the hospital liable for Maya's mom's suicide. It didn't deprive the hospital of a fair trial. The final judgment on the insurance fraud claim should be affirmed. That's where they said she didn't have something, but they billed her for that. The trial court correctly upheld the jury verdict for Maya's claims. This is some heavy stuff with case law. I just don't think I can jump into it much further right now. Mathis, I'm curious what you found in there that was especially intriguing. I'm not sure if you want to just type it in chat. And I'd love to hear from anyone if they know what the current status is and where they stand in that case as far as payment goes, because that's the big question. When will they pay? All right. Let's see if we can jump back up to court with, I think we've got Judge Simpson who might be live right now. Just 1 minute. Judge Boyd is live. Judge Simpson is live. Let's go to Simpson.
Oh, yeah.
Afternoon, Your Honor.
Good afternoon, Judge.
Chris Davis appearing with Myron Moyer, who's present via Zoom.
Just in time for the
Moyer,
bling
can you state your name, please?
Myron Moy, Jr.
Moy. Okay, got it. All right. What are we doing?
Judge, we're asking the court for additional probable cause conference for negotiations.
All right. How much time do you need?
3 or 4 weeks should be fine.
Really? He needs 3 or 4 weeks to negotiate?
Right.
3 weeks should be fine.
Counsel could do it. He used to be able to do it in 2. He's getting old. All right. I'll adjourn probable cause conference October 24th, 2024. Set it at 9 a.m., but you'll get your time block. All right.
Right. Thank
Bond
you.
will continue. All right. Thank you. Good seeing you. Take care, Mr. Moore.
Thank you. Appreciate it.
Court calls the case. People versus Jeff Meyer.
Good afternoon, Your Honor. Eric Langton on behalf of Mr. Meyer.
Mr. Meyer, can you state your name, please?
Jeff Meyer.
Thank you. All right, what are we doing?
Judge, I have been in. Oh, go ahead. Sorry.
Nope, that's fine.
I was just going to say, Your Honor, I have been in contact with the new APA assigned to the case. The prior APA is now on leave, maternity leave, I believe. We are asking for an additional PCC date. I do realize that this would be the second adjourned PCC date. However, I did provide updated contact information for the listed victim so that the prosecutor's office can make contact with the victim. And I do believe we are close to resolution in this matter, Judge.
That's all accurate, Judge. I would appreciate an opportunity to reach out to the victim. He's a teenage young man. He erroneously believes he was placed with his dad. He is technically legally placed with his dad, but he's living with maternal grandparents.
Got it.
We now have that contact information. The offer's been extended already, but we just want
to
to
reach out. All right. October 24th, 2024. Set it at 9 a.m., but you'll get a time block. All right. Will that work for you, counsel?
Yes, Your Honor. Thank you.
All right.
Thank you.
Thank you. Bond will continue.
Thank you, Judge.
Why is he back?
Why is he back?
I've been summoned, Your Honor.
What you say?
I've been summoned.
Court calls case B versus Alexis Perry.
On behalf of the people.
And good afternoon, Your Honor. Samuel Bennett praying on behalf of Miss Perry, who's appearing via Zoom. Miss Perry, can you state your name, please?
Alexis Perry.
Thank you.
Thank you.
You're welcome.
All right, what are we doing?
Your Honor, I'll allow Miss Hughes to update you on the stuff we're working on right now.
Okay.
Police are involved with additional investigation in this matter. I have a phone call scheduled with the officer on Monday. There's follow-up happening on Saturday. We could go out another 2 to 3 weeks, make sure we can get that done.
All right. October 24th, will that work?
Could we do the 17th, Your Honor? I'm already there for an exam. Is that okay? The 17th?
You're not there for an exam on the 17th.
Oh, then never mind. We'll do it. We'll do the 24th.
No, if you're here, are you here for another PCC on the 17th?
Yeah, it's not. You're right. It's a PCC. So 17th would be perfect then, because I could do them both.
Okay. October 17th, 2024.
Thank you.
9 a.m. He doesn't want to see us 2 weeks ago.
I'm okay with that.
That's okay. No, I'm not taking offense. All right.
For 3 weeks next time, Judge.
Okay. Bond will continue.
Thank you, Your Honor. Good to see you. Have a great day.
And you.
Thank you.
Care. So I could take a break and then come back. Is that why balance machine?
Yes, Your Honor.
Is that what really?
I can go kick rocks back.
I thought he was like, never mind. All right, court's gonna stand in brief recess.
All rise.
Everyone gets recess today except for us.
May be seated.
Judge Fleischer is also on break. Let's see. Camera 8, camera 7. What do we have on 8? That was this guy. We watched that. I think we're all caught up with courts. Let's see. Gavin May, he says, I'm just here for the giggles. 17 months. Congratulations. That's a long time, 17 months. It's crazy that I'm approaching just a couple months away from the 2-year mark for the channel, which is just nuts. Let's see. Judge Middleton's not live. Watch Thurston County. We're caught up on that. I think we're all caught up. How can it be there's no more court today? Thurston County. Let me check Thurston to see if they're doing anything. Excited for next week for Sarah Boone. It's going to be awesome. Court 4 is not live. Court 2 is live. Let's see what Thurston's doing.
I do think it's telling that he immediately got into treatment somewhere and is reportedly doing very well there.
Zainabid for the state, Your Honor. As Your Honor indicated, the last monthly progress report that we have on Mr. Johnston is from August. That shows non-compliant, and it shows that he was discharged from intensive outpatient treatment.
I was never discharged.
That he had,
So just let other people speak, please.
that he had stopped that he had stopped attending groups and had not been in contact. As such, the state makes an oral motion to revoke and asks for a full FTC.
Set this for a full FTC in a couple of weeks. Where did you say he was doing treatment, Attorney Duncan?
Yes, Your Honor, he's doing treatment with integrated services.
Weather Watch, welcome to the gallery. Podcast tonight with Thomas, Weather Watch. I'm excited. If this fly will stop trying to fly
It's the state request for a full FTC. It's defense's request to ask for a PFTC to get that documentation.
Yeah, I can get all of it sent.
You know, I have a report from Cascade Community Healthcare that says he was discharged.
Yes.
I mean, but then he was saying, well, no, I wasn't. And so
Because I didn't go to the last appointment. It's
let me
because I'm
speak
going
with
to my
your
other
attorney,
class.
please. Mr. Penrose, let me speak with your attorney.
Oh,
now.
I'm sorry.
Okay. Go ahead, Attorney Duncan.
Yes, Your Honor, I understand. I don't believe that Mr. Johnson Penrose knows whether or not he was discharged. I do know that he quit attending at Cascade to go to an evaluation and start attending at Integrated because he got his evaluation at Integrated in August, which makes sense that that is when Cascade discharged him. I don't pretend to make any representations as to whether or not Cascade did discharge him. It appears they did. But I think the important thing is that he did go and get treatment that is working for him or appears to be working for him. And I understand none of that information is before the court yet, but I would like some time to get that information.
Can I just say I'm not a fan of that lamp that's over Mr. Penrose. That style just does not do it for me. I'm sorry if you have one of those and you love it, that is great. They look top heavy. They look like they're about to fall over. I'd always be trying to catch it. So now if you have a lamp like that, you have to confess in chat. Speaking of throwing shade, now I'm attacking lamps. Bugs, that only one of the four is lit.
How often is he getting UAs?
Once a week.
Go.
Base hides under the couch.
Yeah, we're going to set this for a full FTC there, Attorney Duncan. We'll go for about 4 weeks. November 4th at 10:30.
November 4th at 10:30.
Yes, ma'am. Yes, sir. Yes.
Okay, so November, can I write that down? November?
Yeah, well, I was gonna check. Do you get text reminders and court dates?
Yes, I do.
Judge's mic is off.
Okay. Your mailing address still on Holloway Drive at Chehalis?
Yes, Your Honor.
Yes, do you have something to write with?
Yeah.
November 4th,
We're hearing
At
the
what
judge
time?
through the witness mic.
10:30.
Okay.
That's it for today.
All right, thank you.
You're welcome. Couple more no-shows. Casey Irwin.
No information, Your Honor.
Bench warrant.
Mr. Bitt.
State asks for a bench warrant in the amount of $1,000.
Let's shoot the amount of 1,000 cash or bond. And Sean Souza.
Your Honor, the state asks for a no bail bench warrant on Mr. Souza, given the severe nature of the charge, TV cyber stalking.
Ooh. Domestic violence cyber stalking?
Court warrants from other jurisdictions, no bail warrant will issue on this case. I think that's the end of the calendar.
I believe so, Your Honor. So it's a bit late for me to tell you that Brittany can't hear you and to turn on your mic.
Thank you.
So the court accidentally turned the court's mic off.
Yeah, when did that happen? Feel free to jump in and tell me that
Okay.
anytime, because
think-
that
I think
affects how well could we record it.
I think just a few moments ago.
Okay,
So
all right.
it wasn't a problem for most
All
of the
right.
calendar.
But if you
Either
see,
drink
if
or
anybody
don't.
tells you my mic's not, I'm sure I just hit it up here. And let me know right away. Don't
All
worry
right.
about
Understood.
everybody else. Everybody else
Just
interrupts
have a
me. Why
drink.
should you be any different?
There we go. Okay. Whew.
That's it for today.
That's it for today. They closed it out. Chinny, we've been court stalking. Yeah, we've been cyber stalking court today, and just had a little fun. It's been a quiet day as we lead up to Sarah Boone next week, which is going to just be wild. Tonight we have a podcast coming up at 8 p.m. on this channel. Please ring the bell. I'll build the thumbnail so you can join and talk over there soon. I think we're about done for the day. Courts are like winding down. All our regular haunts that we try to watch are otherwise engaged, doing nothing. Let's see. Appellate Division. Who's that? First Judicial Department in New York, Appellate Division. Okay, now, let me just show you this. We're not going to watch this, but let me show you briefly.
Because of high winds having nothing to do with negligence, right?
Look,
That's what the expert said.
look at the ornate
Right. So you're asking
woodwork.
us to disregard that general proposition that fences can fall without someone being negligent?
No, I'm asking the court to disregard this expert's opinion.
Right, but isn't that one of the elements of res ipsa, that it has to be able to happen in the absence of negligence? That's the primary requirement for res ipsa.
Correct.
So if you're acknowledging, as my colleague just stated, that this could happen generally in the absence of negligence, then that undercuts applying res ipsa as a matter of
I'm not acknowledging that it could happen in the absence of negligence. We're claiming it was negligence. And as a matter of fact, the defendant.
That's a different thing.
That's not the res ipsa doctrine. That's the basic tenet of it, that you have to, for it to apply, you have to show that this is something that happens in the absence of negligence. What?
Right.
Does not occur, I'm sorry, in the absence of negligence.
Does not occur in the absence.
Okay.
She
I'm
had it
sorry, is there a
backwards.
question posed to me at this point?
No. Thank you.
Look at the wood carving, the ornate.
Good afternoon, Your Honors. Elisa Zeltz for defendants' respondents. I just wanted to explain very briefly about the Bo Echo, because one of the plaintiff's arguments has been that the expert's report is somehow speculative. And just to explain why the court was correct in finding that these unforeseen, very strong wind gusts occurred at the time of the accident on July 25th at 6:05 a.m. And that
Okay, we're not gonna stick with that one. It's a beautiful court, absolutely beautiful. But I just saw that we don't normally see stuff out of New York. You're absolutely right, LJ. New York typically is quite quiet when it comes to legal proceedings. Let's see. Kansas is not live. Judge Cedric Simpson is on break. Judge Boyd is live with a translator. Don't think we're going to go back there tonight. I think we're done early, and then we're going to have the podcast tonight, so we'll have time to prepare for the podcast. How would that be, Thomas, if I was actually prepared for the podcast? I'm not sure what we would do in that situation. Let's see. Just making sure. Thurston, Fleischer, Wolf is not live. Chisholm's not even live right now. I think everyone's just got a quiet lull preparing for Sarah Boone. Just enough time for him to do some turf work. What watching like this is going to be awkward. He says we could watch Burnett County, Wisconsin, live from yesterday. How will I make it through the afternoon? You're going to survive. You're going to survive. It's going to be okay. Because here's what I'm going to do. This is actually a good thing. I have to go fix my lawnmower again. Yes, that same carburetor that I replaced is now not working. I'm going to try to get it fired up and get it working again. I'm not optimistic. I don't want to have to change it again. Or it could be nap time. Red Pen says I could go do some housework. But you watch your reel in celebration of my sobriety. I have watched that reel. It's really good. I like it. I feel I don't like watching things that celebrate me on my channel. Does that make sense? It's really awkward for me to do that. Let's see. Yes, we'll have Sarah Boone live next week. That's what we're doing. Have Halloween decorations to put up. We might be talking about that tonight. We might be talking about decorations, Halloween and Christmas and such. Get your stuff done, says Lynn Taylor. Sounds good. It's an early out. It's 3:20 here. It's an early day. Thomas is saying yes. Yes. I know there's at least one or two pictures that I've seen, Thomas, of somebody down in Texas who's already setting up some decorations. Gives me time to work on the boy band dance instruction video I'm making for you, says Debbie. Awesome. I'll send you pics to your burner of my cemetery. Sounds great. Sounds spooky. Will jury selection be televised? No, Natty, and that's what starts on Monday. So we're not sure. I'll be talking with Trial TV Live here later today about that. It's really celebrating your community. I know, but it's like it's a highlights reel. Maybe we can drop a link to it someday. We'll drop a link to it. Does that work, Blackbird Squeaks? By the way, congratulations on your sobriety. That is just awesome. Every day you can add to that date, to that number is a beautiful, wonderful day. Wish I could go lounge in the hot tub. Wish I had a hot tub to lounge in. That would be great. Get the tech spray carb intake stuff. I did it and saved the day. I've got some. I'm going to go out. I'm going to try that, see if that'll clean things up, de-junk it. And if not, I have to take the whole thing apart. At least I know how to do it now. But now the mosquitoes they're getting pretty thick out there now. We're doing the highlight reel. Ari doesn't know it yet. Says cachette. That's awesome. All right, I think that's it. We've stalled long enough. I'm going to release you guys until tonight, 8 p.m. We're taking over the airwaves with the podcast. I'll continue to work on my video audio. Ugh, you were my excuse not to. AZ, I have some advice on video audio. A lot of times less is more. And if you're editing audio on court, if you can do edits for large chunks of video, it's a lot easier than cutting the video up to the pieces you want and then editing the audio. So edit first, then splice and cut. So all the edits apply to the entire thing. I'm not sure if that applies to your situation, but there you go. New iPhone comes tomorrow. I am thinking about getting a new one because they're offering a killer deal. A killer deal. And I normally don't, I usually buy my phone outright, which is why I still have the 12. But it only works if I keep it plugged in. Because the battery just zoom to nothing. All right, tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live at 8 o'clock tonight with the podcast, the Not Relevant podcast. Thomas and I will be here. You should be as well. Don't miss it. Don't miss it. You won't want to miss that one. Early holiday edition, I guess we could say. Early holiday. All right. Have a wonderful day. Please keep in mind we've got several people in this community that are going through some hard times, medical or otherwise. A lot of them asked for our thoughts and prayers, so keep them in your thoughts and prayers, please, as they are it's not a bright, happy day always for everybody. So just be mindful of them. Appreciate that. You guys have a good one. We'll see you tonight. Bye-bye.
Scratch all that. Oh, that was terrible. I apologize.